Hello and welcome to the 2020 Minnesota TZD webinar series. I would like to say it's exciting to see all of you on the other end, even though we can't see you. Unprecedented times call for unprecedented measures, and here we are. This morning's webinar was our kickoff webinar focusing on lessons learned from Norway and Sweden. This afternoon, we're going to highlight the legal aspect. I'm Lisa Kahns. I'm the Traffic Safety Program Manager here at the Minnesota Safety Council, and I am also the Network of Employees for Traffic Safety State Coordinator. We would like to start out by thanking all of our hosts, including NHTSA, Minnesota Department of Health, Minnesota Department of Public Safety, and the Minnesota Department of Transportation. Thank you again to all of our hosts. Before we get started on the official webinar topic, this TZD program is very excited to recognize one of our 2020 award winners. Today, we are going to recognize the 2020 TZD Judicial Court Star Award recipient, Ms. Monica Jensen. Monica Jensen has shown extraordinary creativity to help make Minnesota safe and has been an active participant in the TZD initiative in Dakota County. She is a leader in crime prevention efforts of the Dakota County Attorney's Office and shows constant dedication by spending significant time, energy to identify multiple ways to get the message of safe roads to the communities. Monica is often known as the go-to person in Dakota County Coalition and has also taken the judicial role a step further by encouraging, mentoring new members on being leaders to sustain the mission. At this time, I would like to turn things over to Ms. Monica Jensen to say a few words.
Thank you, Lisa, and thank you very much for this amazing recognition. I'm humbled beyond belief. My sincere appreciation goes to Linda and to Joni, who nominated me, and to the committee for their decision. I know there are many champions worthy of this recognition in the criminal justice system as they inspire me to keep doing this work. I'm super thankful for my boss. I might know Dakota County Attorney Backstrom, who allows me to play in the sandbox with these two wonderful women as co-chairs of our Dakota County Coalition, our wonderful community and law enforcement partners, and the others who believe in the need for traffic safety. We've done so many great things, but as we can see in the headlines, we aren't quite done yet. We are all about our stories, some good, like the accomplishments mentioned, some not so good, like the lives lost or those lives who have been changed forever. The quick version of my story is that shortly after moving to Minnesota from Lake Tahoe, I was involved in a crash where a driver who happened to be impaired was more concerned with tucking the bag of drugs back under his driver's seat than he was with paying attention to the traffic flow, which had come to a complete stop at a red light. And he didn't stop until he landed in my backseat, starting a chain reaction involving multiple vehicles. For over a decade, I endured headaches, loss of movement on my left side, and endless doctor's appointments and physical therapy. But my story didn't stop there. Traffic safety is important to me because of my loved ones, to the victims, and survivors who live to tell their story, and also to the first responders, to those enforcing, those educating, those designing, those in the judicial system, and everyone else who makes the stories right. So on behalf of one of the many judicial champions, thank you for this special recognition and for the opportunity to make a positive difference on Minnesota roads.
Thank you so much, Monica, and congratulations. I've had the pleasure to work with Monica for many years, so this award is extra special for me to be able to present. I would like you also to know that I am today's moderator. I've already introduced myself and given you my background. So before we get going, I'd like to let you know it is the COVID court decisions and challenges, legal and legislative updates affecting traffic safety. So that is today's topic. We do have some housekeeping rules that we need to take care of just before we get going. This recording is going to be, this program is being recorded and will be available on the TZD website within a week. So if there's something you missed, you want to go back and take a peek at it, it'll be readily available for you. Question and answer. This is a big piece of this presentation. We would love for you to be able to ask some question and answers. We will be getting to those at the end of this presentation. But if you could please use the Q&A box that shows on the screen here versus the chat box, that would be great. It's going to be easier for us to grab those questions and get you those answers. Continuing education credits are readily available for this program. We have the CLE continuing legal credits, professional development hours, and post-certification will also be readily available. To find the forms, please go to the COVID Court Decisions and Challenges Legal and Legislative Update webpage, and those forms will be available for you. Post-certification for our law enforcement viewers, post-board credits are also available for this webinar. Please read this important announcement from the post-board. I'm not going to go through all of this right now, but the TZD is a continuing education sponsor as approved by the Board of Peace Officers Standards and Training. This course, COVID Court Decisions and Challenges, Legal and Legislative Updates Affecting Traffic Safety, course number 10211-0063, has been approved by the Post Board for continuing education credit. Peace officers who successfully complete this course will receive 1 hour of continuing education credit. The sponsor of this course has written policy for the investigation and resolution of all allegations of classroom discrimination. This policy applies to all faculty, instructors, administrative staff, and students. A copy of the policy may also be obtained from the sponsor by contacting the University of Minnesota. And now I would like to introduce you to our fabulous presenters. First, we're going to start off with David Bernstein. David is a prosecutor with the Minneapolis City Attorney's Office who specializes in DWI and traffic cases. He attended the full 2-week DRE school and handles both alcohol and drug impaired DWI cases in Hennepin County District Court and the Minnesota Appellate Court. Mr. Bernstein regularly presents DWI related CLEs and law enforcement trainings across the state. He is also the chair of Minnesota's DWI task force, through which he drafts, advocates, and testifies about proposed DWI legislative changes. I am going to introduce you to our other panelists because they will be tag teaming in on this presentation. Our second presenter today is Amy Tripp Steiner. She's a prosecutor for the city of Minneapolis, where she prosecutes both alcohol and drug impaired driving cases. She attended the full 2-week DRE school and has applied that training in the courtroom, as well as being a presenter at educational seminars to attorneys and law enforcement from around the state. Ms. Tripp Steiner previously worked as an assistant attorney general for the state of Minnesota, litigating implied consent cases. And next, I would like to introduce you. Mr. Bill Lemons joined the Minnesota County Attorneys Association in 2008 and currently serves as the Traffic Safety Resource Prosecutor for the state of Minnesota. In 2007, this was a new program in the state, and Mr. Lemons was responsible for its creation and development. In this position, he provides training, research, technical assistance, and supports the Minnesota's prosecutors, law enforcement, and other traffic safety partners. The program is funded through a federal grant from the National Highway Traffic Safety Administration and is administered by the Minnesota Office of Traffic Safety. Mr. Lemons has an extensive jury trial experience in the DWI area and is a frequent presenter at CLE seminars. Thank you again for attending, and I am going to turn things over to Mr. Lemons. Bill, you're on mute. There you go.
Hey everybody, I'm just going to pull up our PowerPoint here. I'm the Traffic Safety Resource Prosecutor, as Lisa said, and let me say thanks to Monica Jensen and congratulations on the well-deserved award that she got today. So what we're going to do here, we've got quite a bit of material, and we're going to try to get through as much of it as we can. We're going to kind of work through it, all three of us, rather than have one at a time presenting. But what we're going to do is we're going to talk about the COVID challenges, things we're seeing in terms of breath testing at court. Amy's going to talk about COVID, and then the three of us will run through the important appellate court decisions that we've seen this year. I'll do the legislative update you about the legislative changes that we've seen this year. And then David is going to talk about kind of a future outlook and things that the DWI task force has discussed and is working on. So I will turn it over to Amy at this time.
Thanks, Bill. Good afternoon, everyone. Thank you for joining us. My name is Amy Tripp-Steiner, and we are going to talk a little bit about COVID. And so what we're going to talk about are some of the things, mind you, this is more from a prosecution lens view of things that we've seen as we're preparing cases during this time, feedback we've received from law enforcement about some of the challenges, as well as just things that are happening in a national conversation. So Bill, if you can go to the next slide, please. So the first is some about DWI enforcement, because COVID, like everything else, is also affecting how DWIs are conducted. So first and foremost, some of the challenges we've seen is how we are protecting law enforcement while they're trying to do their job. While we all know that it's inherently dangerous every time that they have to make a traffic stop, now there's this extra level of this virus to deal with. And so what we're seeing is differences amongst agencies about whether they need to wear a mask or not. And the challenge is when law enforcement has to wear a mask, and so that one of their senses is severely limited. As most of us know, the ability to walk up to a vehicle and smell the odor of alcohol, marijuana, PCP, or other drugs is an important part of that DWI investigation. And so when they have to wear a mask, that does limit that. But you have to balance also trying to ensure the safety of officers. We then also are seeing challenges about protecting the suspect as well. We have suspects that will sometimes be wearing a mask and indicate they don't want to remove that mask because they say to the officer, I know that you're in contact with the public at a much higher rate than the general public. And so I'm worried that I could get something from you. Sometimes people are wearing masks because they're also trying to mask their own odor and a whole other host of issues. That just makes it another wrinkle for law enforcement to be able to do their job. And then overall, the challenges in ensuring the integrity of the investigation, including the testing process. In order for an officer to do the horizontal gaze nystagmus test, they have to be closer than 6 feet to be able to do that. Or if they're going to administer a preliminary breath test, they're also closer than 6 feet. So all of these things have posed challenges for law enforcement. And there's another TZD webinar on November 19th with Colonel Langler and a bunch of other law enforcement that are going to talk more about the specific enforcement side issues. So if you haven't registered for that seminar after this one's done, I'd encourage you to go and register for that one. Then we also are having challenges on the prosecution side. And this has been varying across the state. One of the things we're noticing is that booking procedures are varying. And so jails are trying to balance protecting the health of their population, the people that work in the jail, also with some of the statutory requirements. And on occasion, we're seeing across the state that some suspects are not actually being booked and detained and held as is required by the statute. So for example, in Minnesota Statute 169A.40 subdivision 3, that requires certain types of DWI offenders to be booked, to be held, and for that certain period of time so the prosecution can issue that complaint. So that includes first-degree DWIs, second-degree DWIs, and then for other DWIs, if their alcohol concentration is a 0.16 or more, if there's a child in the car, if the driver's under the age of 19, or if their driving privileges have been canceled as inimical to public safety. So those kind of things sometimes are not happening, which then can delay the process even further. And in conjunction with that are those mandatory bail and conditions of release. We're seeing that if they're not being detained sometimes the fight to get those mandatory bail conditions also is delayed or hampered. Finally, getting cases heard in a timely fashion. As David will talk about in a little bit, if you're in a county that has utilized virtual hearings, you might not see as much of a lag. But if you're in a county where most of the hearings are still being held in person, there has been a significant delay in all types of cases in order to get them done in a timely fashion. And so trying to balance all of those concerns with protecting everybody, as well as trying to move a case along, has been a unique challenge for this year. Go to the next one. So when we're thinking about specifically DWI and some of the normal things that happened before COVID and now things that maybe aren't as normal, there are two different types of breath testing devices that law enforcement uses when they're doing DWI investigations. And once COVID hit, there were certain agencies that stopped using those. And then now, as we've been going further into COVID and seeing that it's not going away, agencies have resumed that. So we have our first polling question here. And so if you know the answer to this first question, whether you're law enforcement, prosecutor, judge, or even if you're a defense attorney watching, if you know the answer, we're asking you to help us out. So the first is, are PBTs being used in your jurisdiction? So hopefully a polling button will come up on your screen and you'll be able to participate in that. For those of you who are watching who maybe don't do much in the DWI world, a preliminary breath test is a handheld instrument that launches cause determination to arrest. So are we getting responses here? Okay, there's the poll. We'll give you a few more seconds to answer on this question. All right. And hopefully we'll get the responses here in a few minutes. So this is great. So we've got, thank you for the folks who responded. Our PBT is being used in your jurisdiction. We got 95 yeses and 5 nos. So this is showing more of a trend going back to normal investigation mode. All right, so then let's go to the second polling question, please. So this relates to the DMT, which is our evidentiary breath test. So again, if you're able to answer, please do so. Our breath tests being conducted using the DMT in your jurisdiction. Again, for those of you who are less familiar with DWI, the DMT is that evidentiary breath test. If you hear that someone has a 0.11 alcohol concentration, that response comes from the DMT. And this is a test that is conducted post-arrest. So we'll take a couple more seconds to give folks a chance to respond. And we'll get the responses here. So again, for this one, we have we have 81 people saying yes and 5 no. And this question we were kind of really interested in because the BCA has indicated a significant increase in fluid testing since COVID started, generally as a result of more search warrants being used, I think, as a way to address COVID concerns. So thank you to all of you who responded on that one. Bill, can you put the next few things on the screen, please? One of the other COVID challenges that we're seeing law enforcement deal with are breath test refusals. Prior to COVID, it was pretty straightforward. If a person was refusing, they can either refuse in their words or they can refuse in their actions by either pretending to blow in or doing things that what we call frustrating the testing process. But what we're seeing now during COVID times is that refusals are not as clear-cut anymore, and that the issues surrounding whether you are asked, if law enforcement is asking a suspect to wear a mask, maybe either because the suspect has indicated that they have had contact with someone who's COVID positive or that they're exhibiting symptoms of COVID or a whole other host of things. And that if the subject either won't put the mask on and if the law enforcement says, well, then I'm going to charge you with refusal, judges aren't always saying that that's a refusal anymore. So for law enforcement, if you are unsure, if it's getting into that murky area, you can talk to your prosecutors about this, but generally the best advice is just to go get that search warrant to get that blood or urine draw. If you're getting COVID-like responses from that suspect about why they're not complying with your breath test. The next part is that like I said, the BCA has noticed an increase in fluid testing, and that comes as a result of search warrants. That is a generally safe option of getting around any COVID concerns, whether the officer is concerned about exposure, if the suspect is saying that they have issues, all of those things, a search warrant. Now, I know for most of the state, getting a search warrant isn't a big deal. I know there's some counties where it's a little more challenging because you have more limited resources. But that is generally the safe alternative. And then finally, COVID challenges are about recommended cleaning procedures. Intoximeters came out back in the end of May or early April. They're the company that owns the DMT instruments and came out with some recommended cleaning guidance. And again, these are just general ideas that are good for cleaning, but also extra important now that we have this virus around. So at the end of this presentation, you'll be able to get a sample guide that we created here in Minneapolis that's kind of synthesizes what intoximeters said for PBTs and DMTs, which include don't use bleach products. If you use a product that contains alcohol, to wait that 15 minutes and things like that, so that you don't have any contamination in your testing device as a result of the cleaning.
All right, good afternoon, everyone. I'm going to talk about virtual hearings, and we're going to start with a polling question. Wondering how many of you in the audience have participated in a virtual hearing remotely? Different platforms, Zoom, WebEx, Teams, Skype. Take a few seconds to get responses on that. All right, and we'll see the results. All right, so I'm showing that 92 people have said no, 35 have said yes. So this will be new to many of you. There are definitely some benefits and some challenges to virtual hearings. I'll start by talking about the benefits. And the first one is obvious. It's very convenient for lawyers, especially. You can travel to different parts of the state or at times different parts of the country in a matter of seconds. And Bill, if you're able to put up the next slide, or well, next picture, there we go. So bottom right corner is a discussion that I participated in Kentwood, Michigan. In the top right is a picture of me. I was at home speaking with a judge in the middle, and bottom right was a public defender. And I was getting some information about virtual hearings. They've done a lot of them in Kentwood, Michigan. And so in preparation for this presentation, as well as another one, I was talking with the judge about some of the benefits and challenges that he has seen. I then had the opportunity to be a member of the public and observe a few arraignments that took part in Kentwood, Michigan. And I did so out of the friendly confines of my home here in the Twin Cities. So like I said, you can literally go across the country in a matter of seconds when you're appearing virtually. This is really convenient for defendants as well. They don't need to arrange for transportation, childcare, time off work. A lot of things that make it difficult to appear in court get resolved by appearing virtually. Parents can have their children at home, hopefully off screen. They don't have to arrange for public transportation. And actually the judge in Michigan said that he's conducted hearings when defendants have been at work and they've been on a 15-minute break or a lunch break from their office. They've stepped out and dialed up on their phone and they participated in a court hearing. So very, very convenient. With that said, there are definitely some challenges. The first and obvious one is the reliability of the technology and the connection. I'm sure you've seen it in virtual hearings you've participated in or presentations. When I was speaking with the judge and the public defender, the judge tried putting myself and the public defender in a private meeting room. And for whatever reason, I wasn't getting the pop-up to go into that meeting room, and I didn't know why. It was my first opportunity that I had using Zoom. When I finally did get into the meeting room after a few minutes, I was speaking with the public defender, and all of a sudden he was mid-sentence and I lost my connection. I felt horrible. I came back on, I apologized. By that time, the public defender had left. I asked the judge to forward my apology. But connection can be a problem. And the judge told me this was especially true when defendants are on their phone, which have a less reliable connection. And defendants have been in their phone while in their vehicle. Of course, here with traffic safety, that's a concern about distracted driving. But even if they're not driving, if they're parked on the side of the road, connectivity can be a problem, especially while on the phone. Making an accurate record is also a very big concern, not only with connectivity problems, but it's difficult when there are lag times in the technology. There are times when people are interrupting each other. There are times when people are speaking, but they're on mute. And so when they unmute, they have to recap what they just said. Objections are difficult when you are purposely interrupting them, but making sure that you have an accurate record is really, really important, and it's a challenge. The other challenge that frankly I have not dealt with yet is cases involving interpreters. That's going to add another layer where you need to make sure that there's a sufficient ability for the interpreter to hear each party and to provide the interpretation. So it is really, really important to make an accurate record. Finally, it's draining. When I was talking with the judge in Michigan, he admitted to me that when he's had a full morning, a full afternoon of hearings, by the end it's exhausting. Often when you appear on the computer, you're looking straight into your microphone as a party, and you don't have the opportunity to look down and maybe work on some other stuff. You feel like you're more in the spotlight. I had the opportunity to do some training with some new law clerks in my office, and I asked for feedback after that, and the law clerk said, look, we get that we would have spent the same amount of time in the office, but the fact that we did it all virtually was just draining. So that's something to be aware of as well. The amount of time that you spend can be very difficult mentally. So I think as we move forward, there's a good chance that we'll see some virtual hearings, especially for early appearances, arraignments, pretrials, perhaps some limited contested hearings. But I also think there are sufficient challenges that when you have contested hearings, it's preferable to be in the courtroom if possible.
That's maybe a nice segue into the case law update. So we're going to go through the important appellate court decisions from the last year. And I think Amy has the first one here.
All right, so our first case we have here is Jensen versus Commissioner of Public Safety. And this case is a nice reminder about in DWIs, there's generally a civil license revocation side and the criminal prosecution side. And often the law runs together. What's good in one is what's good in the other. But this is one of those examples of on the license revocation side, strict compliance with statutory requirements is absolutely mandatory. This was a case where the driver hit a child, injured the child, and drove off. Law enforcement found her later, suspected that she was impaired, and she was arrested for DWI and criminal vehicular operation. The deputy went and got a warrant for blood and urine, and then when taking her to the hospital, directed a blood draw and did not tell her that refusal to submit to the blood or urine test was a crime. The district court affirmed, which we call sustained, the license revocation, saying it was a CVO. And they can't refuse. Under the statute, if there's a CVO charge, then they can't refuse that testing. The Court of Appeals reversed, and they found that that search warrant advisory is mandatory. and that even though this was a criminal vehicular operation case, that didn't eliminate the deputy's duty to give the warning at the time that the blood or urine test is directed. And so the practice tip here is to just always do it. While this particular issue might not be fatal in the criminal side, State v. Mike gives a little bit more leeway in the criminal side. It will be fatal in the implied consent side. And sometimes officers are like, well, it doesn't matter, you know, we'll get it in the criminal. No. That pre-license, pre-hearing license revocation that happens so immediately is very important. It's going to be deterring that driving conduct. It's used for enhancement. There's a lot of benefits to get that done. So please give that search warrant advisory, regardless if it's a regular DWI, a CVO, or CVH. We need law enforcement to be making that advisory.
Yeah, I'm going to quick piggyback off of that last point that Amy just made. Professor Steve Simon at the University of Minnesota, my predecessor with the DWI task force, did some studies and research on this. And his research established that early intervention is the most productive intervention, and specifically focused on that license revocation, finding that that is a good deterrent to future DWIs. And so that license revocation is really, really important. And so, as Amy said, you want to follow the proper steps to make sure that you do get that license revocation, and don't gloss over that.
And, you know, with the criminal cases, as we mentioned, these cases are taking a lot longer to progress. And so unlike wine, cases don't get better with time. And so you're going to want that license revocation there because you don't know what might actually end up being the criminal conviction.
So with that, we'll move on to the next case, State versus Anderson. This relates to enhancement. I'll try to make this fact pattern as easy to follow as possible. DWI number 1 occurred and DWI number 2 occurred 2 months later. DWI number 1 was going through the criminal court process, while DWI number 2 moved through the license revocation process. And that's the license revocation from the second DWI was sustained. I believe it was April of 2017. So that was during the pendency of case number 1. What the state did was they waited until after the license revocation for DWI number 1. They then charged DWI number 2 as an enhanced gross misdemeanor based on that license revocation from DWI number 1. So again, and I may have mixed up the terms here, license revocation from DWI number 1 was pending when DWI number 2 occurred, and the state waited to charge number 2 until the license revocation from number 1 was sustained and used that to enhance. The defense challenged that enhancement, and what the Court of Appeals held is that a license revocation is present as an aggravating factor as of its effective date, may be used to enhance another DWI charge once judicial review has occurred or the right to review has been waived. And so in this case, they upheld the license revocation and the enhancement of DWI number 2, finding that the judicial review had occurred. And so it was proper for the state, or at least allowed for the state, to use that first license revocation to enhance the second DWI. So if you're faced with a situation where 2 DWIs happen close in time, law enforcement should process them as usual. Prosecutors, you have the choice. You can either charge DWI number 2 right away, or you can wait until DWI number 1 comes to completion, either through the criminal process or the license revocation process, and use that to enhance DWI number 2 when you charge it. Either option is allowed pursuant to this Anderson case. Now, there is an important point that they made in Anderson that's going to lead into the next case we talk about, and that is that a license revocation is effective when the Department of Public Safety notifies the person of the intent to revoke. So when notice is provided, that's when the license revocation is effective for enhancement purposes. And that leads us into the Moore case. So Moore is unpublished, but I still think it's worth talking about. This was a felony DWI based on 3 priors in 10 years. So this was the 4th. The state submitted evidence of the 3 priors, 2 of which were convictions, and the third, they relied upon the license revocation and more challenged the sufficiency of the proof of enhancement. What the Court of Appeals did was they found that the driver's license record, which was entered into evidence, the certified record, provided evidence of the occurrence of the revocation, but not the notice. If you remember in the last slide, the notice is what makes the revocation effective. And they held that the state did not submit sufficient evidence to establish notice of the revocation. And so they reversed and found that that certified driver's license is not enough evidence to establish proof of enhancement. It was then remanded to the district court for sentencing as a second-degree DWI. So the practical tip for prosecutors that comes from this case is, if you're using a license revocation to enhance, the certified driving record is not enough. You need to obtain and submit notice of the revocation along with the certified driver's license. The Department of Public Safety does keep record of the notices. That's in breath test cases. Typically, law enforcement will print and hand that to the suspect once the breath test results are printed. For blood and urine tests, there's a notice that gets sent out after the results come back. But that is the notice you need to submit in evidence if you're going to use a license revocation to enhance an additional charge.
That brings us to the Polar case, State versus Polar. This was actually a published case by the Minnesota Court of Appeals. Has to do with stopping somebody for a seatbelt violation. The officer stopped the person, observed the driver not wearing a seatbelt, stopped the person and approached the vehicle, and the driver realized that the driver was in fact wearing a seatbelt. Here, the Court of Appeals held that the officer still had reasonable articulable suspicion that the defendant was not wearing a seatbelt based upon his observations, and that the stop was justified. The fact that the defendant was wearing a seatbelt after he was stopped did not render the stop invalid. The practice tip for law enforcement in this case is to document as much detail as possible in your reports about what you saw, where, your point of view, where you were, what you had observed, just as much detail as you possibly can into your reports, so that you can also be able to testify in some detail about what you saw.
Birkeland versus Commissioner of Public Safety, the left turn statute. This is the one that made prosecutors and law enforcement go, oh. So this is a case here with our lovely little graphic. The driver made a left turn. So if you look at the graphic and there's spot number 3, pretend that that is a dedicated left turn lane. Officers behind the driver, and the driver then makes this wide left turn and goes to the outermost lane and not the inner lane. So that was the basis of the stop. And that was the only basis for the stop, excuse me. And then the Court of Appeals reversed and said that a driver does not need to turn into a specific lane of traffic when making a left turn from a left turn lane. Now, I realize that law enforcement is screaming at the computer right now saying, but it's not safe. We all know that. Anyone who's ever driven a motor vehicle knows that making that big wide turn is unsafe. But the Court of Appeals was limited to the language in the statute, and the language in the statute does not indicate that the person has to turn into a specific lane. And they compared that to the right-hand turn lane turns, which talks about that a right turn shall be made as close as practical to the right-hand curb or edge of the roadway. So the Court of Appeals had to follow what the language was in the statute. So officers, you cannot make a stop based solely on this particular issue of them making a wide left turn. If you are unhappy with this holding, has to be a legislative change. So go and talk to the people who make those changes, including maybe the chair of the DWI task force, David Bernstein, so that we could get this changed if it is bothersome to you.
Okay, the Kansas versus Glover case, this was a United States Supreme Court case, obviously coming from the state of Kansas. Here, the deputy ran the plates and determined that the registered owner of the vehicle was revoked. The deputy initiated a traffic stop of the vehicle, believing that the registered owner was the driver who would have been revoked and driving after their license was revoked. There was nothing to contradict that kind of assumption that the registered owner was driving. There was nothing that he had observed that would contradict that. The United States Supreme Court held that the stop was reasonable as long as the deputy lacks any information that would negate that inference that the owner is the driver of the vehicle. The decision was 8-1. The decision was 8-1. It was the majority opinion was written by Clarence Thomas. There was obviously one dissent. Justice Sotomayor dissented, concerned about the demographics and whether this would lead to random stops or stops based upon illegal immigration, I think was probably her biggest concern, and whether law enforcement would be stopping people in that regard, whether it was opening the door too wide. Clarence Thomas indicated that it was a narrow holding. He did say that he did address Justice Sotomayor's concern, saying that they weren't opening the door to just stopping people or stopping people that they believed might be illegally in the country. There was two concurring opinions. Well, there was one concurring opinion written by Justice Kagan, joined by Justice Ginsburg. So of the 8, 2 of them were part of this concurring opinion, where they read it even narrower. And they talked quite a bit about the difference between revoked and suspended, noting that this was a revocation rather than a suspension, and that the person that's revoked is likely to, has previously shown that they don't obey traffic laws because it obviously to get revoked. Just talking about the difference between a revocation and how you get revoked. Suspension, you could get suspended for not paying your child support or not paying fines and that type of thing. So she was kind of drawing a little bit of a line between revocation and suspended. Minnesota previously addressed this, the Minnesota Supreme Court in the Pike case, State versus Pike. They had ruled exactly the same as Justice Thomas's majority opinion. And so the practice tip here for law enforcement is to keep doing what you're doing.
So real quick, before we talk about the Schwartz case, we received a question about the Anderson case that I want to address. And feel free to send questions as they come to you. We'll address them as we can, but this is a really, really good question that I want to address now. The question was whether law enforcement should issue a misdemeanor citation and the prosecutor then quash the misdemeanor charge after the fact. And this person was asking because the citation is a charging document, and I stated the charges should be held. I'm going to emphasize a couple of things. First of all, law enforcement, keep doing what you're doing. I don't want to act as your command staff. I don't want to tell you how you should process cases. If your normal practice is when you see that first DWI, you cite them or book them as a gross misdemeanor based on that prior, continue that practice. What the Anderson case talks about is when that notice becomes effective from an evidentiary standpoint, and that gets to upholding a conviction. What they addressed in that case was the sufficiency of the enhancement. And then the Moore case talked about sufficiency of the evidence for the conviction, which is a proof beyond a reasonable doubt standard that the prosecutor is responsible for. The license revocation, the Attorney General's office handles. But your standard as law enforcement is probable cause. And if you see a prior in that person's criminal history or license, driver's license record, as you're reviewing it, that is probable cause. and the prosecutor will determine whether there's sufficient evidence to prove that beyond a reasonable doubt. So again, law enforcement, keep doing what you're doing. And if you use that prior to cite or book with an enhanced charge, you can continue doing that. So thank you very much for that question. That was a great question. Let's talk about the Schwartz case. In this case, the defendant was charged and ended up pleading guilty to a DWI controlled substance per se charge. As I'm sure you all are aware, statute 169A.20 subdivision 1 parens 7 criminalizes the presence of any Schedule 1 or 2 controlled substance in the person's body at the time of driving, operating, or physical control of a motor vehicle. And that's what they were charged under. They appealed, arguing the plea was inaccurate because the defendant did not admit that he knew or had reason to know that the substance was in his body. The Court of Appeals upheld this case, and what they found was that this charge, the per se charge under subdivision 1 parens 7, does not require proof that the driver knew or had reason to know that the substance was in his body. 2 points of note here, well, actually 3. The first is that defendants can bring what's called an involuntary intoxication defense, which is written in the statute. So if they're going to claim that someone slipped something in their drink, for example, that is an affirmative defense that they can allege. It does require evidence. So they can bring that charge. That doesn't change, this case doesn't change that. This case simply says it's not the prosecutor's burden to prove that they knew or had reason to know based on this statute alone. With that said, law enforcement admissions are always really helpful. So any information you can learn is great to document in your report. The other point I want to mention is a couple of years ago, there was a statutory change regarding intoxicating substances, which is under subdivision 1 parens 3. That charge does have a requirement that the defendant or suspect knew or had reason to know that the suspect was in his body. So the standards under subdivision or parens 3 for intoxicating substances is different than the standard for the per se controlled substance charge. For that matter, under parens 2, that standard is not there for under the influence of controlled substance. So this knew or had reason to know requirement is only applicable to the intoxicating substance charge under parens 3, not applicable under parens 7. With that said, the Minnesota Supreme Court has accepted review of this case. And so we'll see what happens.
The Stevenson case, while this is an unpublished case, this is important for any prosecutors who are listening. This is a good practice tip reminder. This was a DWI, and the certified driving record was admitted in its entirety to show some of those priors. And but the problem here was that nothing had been redacted. And so the Court of Appeals held that the admission of the unredacted records was plain error, but didn't actually affect his substantial rights. There was so much evidence of his guilt for the DWI. But for the practice tip for prosecutors is that if you get that certified document, that stuff that's unrelated to the prosecution should be redacted, but that you should talk on the record about the fact that it is certified, what the redactions were. And best practices would be to have an unredacted copy entered as a court exhibit, and then you have your evidence that's exhibited, entered as an exhibit.
We had a question come in about whether federal convictions can be used for enhancement. I just let you know that we're gonna get to that in the presentation today. So that brings us to a couple of cases, Johnson and Hagerman. Both of these are currently on review at the Minnesota Supreme Court. As we talk about McNeely was the case in 2013 where the United States Supreme Court ruled on exigent circumstances, and they said that you have to look at the totality of the circumstances, and it had to do with blood testing. In that case, they said you needed to get a search warrant for the blood test in order to do the blood draw, which has led us to change our practices to getting search warrants for blood and urine testing. They talked about totality of the circumstances, and it actually overturned a prior Minnesota Supreme Court case that said that the dissipation of alcohol by itself is enough, that you don't need to get a search warrant because alcohol dissipates and time is of the essence to getting the test. So McNeely actually overturned a Minnesota Supreme Court decision. And then, of course, McNeely led to Birchfield, which was 3 cases that were consolidated at the United States Supreme Court, talking about our crime of refusal and with regard to breath, blood, and urine. And they said that breath testing was a search incident to arrest, but you cannot criminalize blood test, a refusal to do a blood, unless you have a search warrant or recognized exception. So we had to get a search warrant in order to make refusal a crime, generally speaking. And then there were a couple of cases at the Minnesota Supreme Court subsequent to that talking about urine testing, and that was Thompson and Trahan. So the Minnesota Supreme Court then ruled, when we talk about the Birchfield and McNeely, I think it's kind of important to recognize that when we talk about Birchfield, we're talking about that United States Supreme Court case, as well as Thompson Trahan. That's what the court has referred to as the Birchfield rule. And they said that Birchfield is retroactive, and by retroactive, we mean that it's applied backwards in time, so that somebody that's convicted of refusal prior to Birchfield could bring a petition for what's known as post-conviction relief, ask that the court vacate their conviction for refusal of a blood test because they didn't have a search warrant. And if they're convicted, say in 2014, they would have been allowed to bring that petition. And the court said that can be granted. It's on a case-by-case basis. But they left open this question of whether McNeely itself is retroactive. And these Johnson and Hagerman are addressing that question. So in essence, the state's argument is that the Birchfield rule is retroactive back to 2013 when McNeely was decided. Both of these cases, Johnson and Hagerman, their refusal convictions were prior to McNeely. So one was in 2011. Johnson's conviction offense was in 2009. And they want to have their convictions vacated. And the question here is whether McNeely is retroactive, because we did have a prior case at the Minnesota Supreme Court that was the opposite decision of McNeely. So that, in a nutshell, is the Johnson and Hagerman decisions and retroactivity of McNeely. And this is probably an area where I probably get the most questions from prosecutors, is retroactive of Birchfield, which I think is generally been decided, but now retroactive activity of McNeely. As we move on to the legislative update, there isn't a lot to talk about as far as new legislation. There's nothing big that's going to significantly change what we're doing. But let me run through the things that have occurred with the last legislative session. The biggest change to 169A, the DWI statute, is in the definition portion, 169A03, and then in subdivision 18, it's changed the definition of peace officer, and that statute lists 4 things that a peace officer has the powers of arrest to arrest somebody for DWI, and it lists 4 things: state patrol officers, U of M, that county and city police departments. And then number 4 is changed to just read a state conservation officer. So a state conservation officer will have arrest powers to arrest for the DWI statute. Previously, it was not for, they could not make an arrest for DWI in a motor vehicle. The DNR could only make the arrests for the other types of vehicles. And where this became a problem, the DNR, just as some background, they go through the same training. They go through the field sobriety training. They go through the DMT breath test training. So they're trained to make DWI arrests. They do that as part of their normal job for motor vehicles and for ATVs, snowmobiles, those other types of vehicles. But where it became a problem, the DNR is not going to be arresting people on the interstate, but where it becomes a problem is when people are putting their boats in and out on the boat ramp. And in this situation, the person's technically operating a motor vehicle. The DNR would not have the power to arrest. At this point, they would have to call in the county sheriff or the local police department to come and or make the arrest and process the arrest. Otherwise, they would have to probably wait for the person they would have to catch them before they pull the boat out, or they would have to wait for them to operate the boat and leave. So this will give the DNR the power to make those arrests at the boat ramps. Another change is with 169.791 subdivision 5. This is creating an exception for failure to, well, it's creating a couple of exceptions for failure to produce proof of insurance. This is not the no insurance statute, but the produce proof of insurance statute. The first one is for buses and commercial vehicles of the Metropolitan Council. The Metropolitan Council was created about 50 years ago by the Minnesota legislature. And I think they provide a number of services, but what you're talking about here is the Metro Transit buses, as well as the number of other ones, the Metro Link buses, or the Transit Link, Metro Mobility buses, as well as any other commercial vehicles that they would have. The second exception that was created this year to this statute is for commercial vehicles that are required to file proof of insurance under Chapter 221. And then if you go look at Chapter 221 for commercial vehicles, it spells out the type of and how much insurance they need to carry, the insurance requirements, but it requires that be filed with the state of Minnesota with the Commissioner of Transportation. So they still have to have insurance. They need to actually file that with the Commissioner of Transportation, but they don't need to produce it under 169.791. And finally, the last exception that was made is for school buses, as defined in the 171 statute.
Hi, it's Lisa. I just want to interrupt real quick and let you know that we will be going on until about 2:10 today. We'll end the presentation right around 2:05 and then allow some time for Q&A. So thanks for sticking around.
So the interim inspection certificate, this is creating an interim inspection certificate. It was, these are issued by State Patrol after they do the inspection of the school buses. Here it's interim. The company does their own inspection and can issue their own interim certificate that's good for up to 12 months. Drivers are required to give information when they're involved in collisions. Change was made that they don't have to show their driver's license or permit to the peace officer that, or they only have to show it to the peace officer. They don't have to show it to the other driver. And then as far as providing their address, that was changed to read mailing address or email address. And they still have to, the insurance is actually under paragraph B, but there weren't any changes made for insurance. I'm going to kind of gloss over some of the charging issues that we see here. Just to correctly charge a case, you need 3 statutes. The offense, obviously, 169A20 isn't good enough. You have to spell out exactly the statute they're charged under. Level of offense, that's the misdemeanor, gross, felony, and then the penalty is the maximum penalties. A few years ago, the courts lobbied for this change. Everything used to be motor vehicle, and the courts, the judicial branch, lobbied to break it out into subdivision 1 for motor vehicle. Motorboat is 1A because it had to do with where the fine money went. And David will talk a little bit more about what the task force has talked about in that regard. So this is 169A20 subdivision 1. And then of course 1A, 1B pretty much mirrors this, but you have to identify in the charging document whether it's influence of alcohol, controlled substance, intoxicating substances. So we're going to go to some of the frequently asked questions that we get. I think David was going to take the first one here. The question that we get, can I enhance a DWI charge based upon a prior from Wisconsin where there's not a right to counsel?
Yeah, we'll go through this quickly. There was a line of cases, Nordstrom and Friedrich, which initially answered that question no, but that case law has since been revisited. And there's a line of cases, McClellan, Lawful. You can email me if you need the citations for that, in which they said yes. There was a recent case decided at the Court of Appeals that I handled. It was unpublished. Jones, I believe it was decided in June or July, that has the analysis on that. But the underlying answer to that question is yes.
I think the second one, I think Amy was going to take, what can I charge for controlled substance DWI if the person has a prescription?
You can charge if the person is under the influence of a controlled substance, which is 169A subdivision or parent 2. And you can also, if there's a schedule 1 or 2, you can still charge that out. At the time of charging, you don't know if they actually do have a prescription for what they're claiming and if it was used in accordance with that prescription. And the prescription drug defense is only applicable to the per se, not to the under the influence. It's an affirmative defense and they have to provide that information post charging. So you can charge that out and then deal with that if they can show that it was actually used in accordance and there's no other substances that they weren't supposed to be using with it.
The third frequently asked question is about prior convictions from federal courts, tribal courts, or other jurisdictions. And the issue here is when you look at the definition for prior impaired driving conviction under our DWI statute, it talks about our statutes, of course, and then there's the last one, which says that a statute or ordinance from, and the keywords are another state. So the question is whether it's talking about the other 49 states and specifically their state courts, or whether it's broader than that, whether state would be maybe under the dictionary definition of a state as a government entity rather than the 50 states, if that makes sense. You can actually get a DWI conviction in federal court. They prosecute DWIs. The U.S. Attorney's Office prosecutes DWIs occurring on, a good example is national parks. And they actually have a refusal crime for national parks as well. So federal court, if you had somebody in, say, Nebraska, federal court in Nebraska, or I suppose even Minnesota, can we count those priors? The federal courts would be bound by the same U.S. federal constitution that our state courts would. I can get you an order that was written by Gordon Moore, who's now on the Minnesota Supreme Court recently appointed this summer from when he was a district court judge, addressing that and saying that you could count federal convictions. And then on the issue of tribal courts, he had said that you cannot, because the tribal courts are not bound. I think the reasoning had to do with that they don't have to follow the same United States Constitution, the Bill of Rights, the same types of guarantees. But tribal courts, courts from other countries, another example might be like the District of Columbia or some U.S. territories where you might have a DWI conviction or come across one, and whether you can count those or not, whether that's obviously DC isn't a state. The last point here is for prior convictions, do we go by the date of offense or date of conviction? This where the answer is pretty simple. The Court of Appeals has said that you can go by either one. You could go by the date that the prior impaired driving related loss of license, and that's effective when the revocation is served on the driver. For breath testing, it could be as early as the date of offense. So if they got a DWI the next night, even though that revocation hasn't taken effect, you could count the prior when they're served with that revocation. You can also go by the date of conviction. So if 6 months later they're convicted, you could go by the date of conviction. So suppose that the date of offense was outside the 10-year look back, but the conviction was within the 10-year look back. You could go by the date of conviction. You can enhance it. It gets a little interesting because DWI e-charging is going to retrieve the date of offense on these, or the date of the revocation when the revocation becomes effective. But if you see that, if you double check it and find that the conviction date was within 10 years, then you kind of need to take this is one area where you'd kind of take e-charging off of autopilot, and you could enhance it based upon the date of conviction. So I think David's going to talk about the future ahead.
And Lisa, I'm very mindful of time. I'll try to run through these next 3 slides in 60 seconds. And then we can get to the Q&A and make sure we leave time for closing remarks. So what did not pass at the legislative session last year that we could see next year? There was a bill introduced to combine DWI subdivisions to eliminate distinction in the types of vehicles that could be proposed again next year. There was another bill which mandated ignition interlock for offenders who obtained a second DWI in 10 years or third in a lifetime in order to qualify for license reinstatement. That bill, there have been variations that have been worked on for years, but I would anticipate some variation of that vehicle to be, bill to be introduced again next session. Finally, the DWI task force bill, I won't read the bullet points there, but the task force is a huge proponent of ignition interlock, and we want to eliminate barriers and increase incentives for individuals to enroll. And so the bullet points there, except for the last one, were all meant with that purpose. And if you have any questions about the task force initiatives, you're welcome to email me, which takes us to the next slide. Task force initiatives that we're working on, the ignition interlock barriers and incentives bill that I just mentioned, we'll probably reintroduce again next year, again, some variation. There's also a DWI parity bill that we discussed. There's an issue with executing search warrants across state borders in outer Minnesota, greater Minnesota, and reporting them through e-charging. And so we're going to address that and perhaps introduce a bill to allow those to go through e-charging. Finally, there are marijuana legalization discussions that have been happening for years. And if legalization happens, I've talked with many officials in states, including Colorado and others who have legalized, and they have suggested get ahead of this. And so the task force is going to be advising the legislature on DWI marijuana related bills. Lastly, roadside oral fluid testing. Amy and I are working, and Bill as well, on this. We have a committee who is working on a pilot project to allow for saliva testing roadside, which would establish the presence of a number of controlled substances. That would be used like a PBT to establish probable cause to arrest and probable cause to obtain a search warrant for blood or urine draw. And so there would still be a search warrant obtained after arrest. This is simply roadside as an investigative tool. And so we're working on a bill to establish a pilot program to begin using this instrument, documenting a report with our results at the end of the pilot project. So you'll hear more about this, I think, in the next year. We'll leave our contact info up there if you want to contact us, but otherwise, I want to thank you all, and I will turn it over to Lisa to lead the Q&A session.
Much. Great presentation, so much to be shared. One thing I do want to remind you of, several questions came in. Yes, this is being recorded. So please, please, please feel free to go ahead and watch this and get all the details. It'll be posted on the Minnesota TZD website here within a couple of days. I'm going to go ahead and share the screen and we're going to start taking some questions. There's quite a few of them that have already popped in. So let's start with in our panelists. Let's see here, my screen is not cooperating with me right now. So I'm going to do this. We're just going to leave their contact information up and we'll go ahead and answer question and answer from here. One question that has come in that I think you can see is any thoughts on the governor's executive order 20/01, specifically section 16 deadlines governing proceedings in district and appellate courts suspended during peacetime emergency. Somebody want to take a stab at that? I'm not having any takers on that one. No? Okay, we'll go to the next one. Yeah,
I can just say, I would need to review the specifics of that order. I'm not sure off the top of my head exactly what's contained in there or the exact language. Obviously, the goal is to keep everyone safe. And so we're going to monitor COVID as it progresses, and the governor will make decisions that he believes are in the best interests of the safety of all Minnesotans, and the district courts, while the appellate courts and Justice Gildea will issue corresponding orders. This is where you might see some more remote hearings. Implied consent hearings are happening virtually. And so maybe you see that. Otherwise, court appearances are getting postponed. And that isn't great for the prosecution, but it is what it is. And we will obviously follow whatever orders are issued.
Excellent. Thank you so much. Another question that came in, all RX substances which alter consciousness or sedatives are dispensed with labels, do not operate motor vehicles or dangerous equipment. I think that was more of a statement than a question. Can you make DWIs on Lime scooters illegal? This is food for thought, I guess.
Yeah,
yeah, go ahead.
I'm sorry, Lisa. This was posted by Anonymous saying, asking for a friend.
Yeah.
And Amy and I are going to say, we know you, Anonymous, and we will respond to you.
Okay, thank you. That's awesome, posting for a friend. And I think this is going to be the last question. I'll bounce back to make sure that we've hit as many as we can. I have some county attorneys stating we must wait to sell forfeit vehicles till the peacetime emergency has expired, but it seems they just keep extending it, causing an issue with storage. Any feedback on that?
I can answer this one quickly too, with unfortunately not much of an answer, but
Right.
Forfeiture is being heavily litigated and argued both in the courts and at the legislature. Jurisdictions are varying significantly in what they're doing on forfeitures. And so I don't feel comfortable, and I don't think we feel comfortable as presenters giving you advice on forfeitures, because it's really going to depend on what your jurisdiction is telling you to do. So I apologize, I don't have broad advice on that question.
No, that's awesome. We are going to move into closing and wrapping things up. As mentioned earlier, I do want to remind you, there is an evaluation survey. So please feel free to jump onto the chat and click on the link, or watch for the survey that will be coming to your inbox, and take a couple minutes to fill out and let us know what you think about this virtual format and some upcoming webinar series. Follow us on Twitter and Facebook and TZD. Make sure that you're following us on social media to get the best of the best and what's updated in real time. I want to bring to your attention the next webinar is Wednesday, October the 21st from 10 until 11. Case reconstruction, building your case after leaving the scene. And lastly, we hope you sign up for additional webinar series and the upcoming webinars that will be happening. It's not too late to register for these. Please feel free to go right online and get signed up already. A full listing of webinars and details can be found online. And please keep in mind, these are free, but registration is required in order to get the link. So you do need to take a couple extra minutes to sign up. And with that, I'm going to share a TZD message for this webinar series. Our work to reduce fatalities and serious crashes may seem harder than ever right now. Hold your head high and know together we are stronger. Together we can make a difference. Together we can make our roads safer for all road users. And together we can get to zero. With that being said, thank you again to our panelists. You did an absolutely amazing job. I would be remiss if I did not say, if you're driving, please drive safely because it is snowing out. So keep your eyes on the road, your hands on the wheel, and your head in the game. And have a fantastic afternoon. Thank you.